Good morning, good afternoon, or a very good evening. My name is Yunus, also previously known as Krasimir. In this short podcast, I will be introducing a master index, bibliography, and a preview from case number 1. What it's worth noting is that I'm not a professional in the sense of being a professional podcaster. Therefore, I'm learning through the actual recording. So I'm hoping that the viewers will be able to focus on the data and not on my errors of making a verbal mistakes and how my brain is functioning due to my skipping data and how actually automatically select as to what will focus on to presenting from the data. My aim is to focus only onto the four corners of the documents. At the end of the short introduction and the preview, then only then I will make a very short analysis in some of the documents without having to be going backwards and forwards whilst disclosing the documents. Now, it is also very important to note that all of these documents are in the public domain record. Therefore, I'm not going to keep repeating for each section to what actually it is, such as public domain and on and on. So I would like to begin just with case number 1, which is the Housing Act 1988, section 17. In this case, it's life. And I have a case number 2, which is myself against James and Cole solicitors. Preview documents bundle in preparation, and they're also available in a different platform. So we have case number 3, which is Equality Act of 2010, section 15, 20, 21, and 149. 149 and negligence. So that is myself against Brighton Metropolitan College, now Chichester College Group. A preview full bundle in preparation, just like going all the way down to case number 6. The documents are available, it's just a matter of me putting them into the right order so they will be coherent in the sense of following from A to B and so on. In case number 4, we have the National Health Service, which causing a long-term paralysis. Then unfortunately my partner passed back then. So in case number 5, we have Equality Act, and again it's a negligence. His Majesty's Courts and Tribunal Services, institutional discrimination and sustained procedural negligence. Case number 6, it's a legal professional negligence, and this is related to case number 1, the defendant's solicitors, which is Dean Wilson. So in the short bibliography, which is a truly very short indeed area of interest, which I'm passionate about, is science fiction, movies, language analysis, forensics and linguistics. It is how my brain functions, where I feel comfortable. Discovering the secrets of language and its mechanism in all fields, it makes sense for me to think as to how I think and how my brain is engineered to innately analyze data. Ethics and equalities, this is something that I have been contemplating for quite some time, requires engineering, not hypothesis and statistic. This was generated by myself on the 19th of March 2026. So I'm going to begin with the short bibliography and documents. Document 1 and 2. We can see on document 1, I'm just slowly zooming in. So this is a certificate of naturalization. We can see my previous full name, which was, one moment, Ivanov Krasimir Krastev, which that was Krasimir Krastev Ivanov. I've just zoomed a little bit more so it will be visible. Where I was born, Varna, Bulgaria, 1st of August 1984. Certificate number and reference number also clearly visible. The day of when I became a British citizen, which is 23rd of December 2013. Document Document 2, we have my passport, which is Tarek Yunus Emre, 1st of August 1984. Still the same place of birth, just like in document 1, which is Varna, same date, 84, 1st of August. You have a passport number here, which none of that data has been redacted. We have document 3, which is a deed poll, change of name, previously Krasimir Krastev Ivanov, now Yunus Emre Tarek. That part here has been redacted. And I'm just going to zoom a little bit more. You can see the document, apologies. So that was signed and dated. Just going to zoom out. So this document here is, whilst most of the viewers might consider it as irrelevant, there is a reason for it to be in this bibliography. I was very privileged to receive an award, which back then it was called the Chairman's Commendation Award, and not a service award, which that's what has been worded now, as I've lost the actual certificate. So this is a Chairman's Commendation Years of Service Award, and it's been dated on the 23rd of September, to whom it may concern. As I mentioned, I'm not going to make analysis as to what it's actually the purpose of that document for me disclosing it until the end of the documents are being available in the public domain. So this is the public domain record preview case 1, statutory succession under the Housing Act 1988, section 17, case number, called Brighton County Court, parties myself, defendant Drive Manor, and the property is basement flats BN2 1HA. So in document A and B, we have general form of judgments or order. So I'm keen to focus on this document from the 14th of November in document A, 14th of November 2025. So I'm just going to zoom a little bit more. So we have here the defendant reference number, Drive Manor Limited. Is part 3, it's where I'm keen to focus on. That the claim is made under the Housing Act of The Housing Act, it's made under the Housing Act 1988, Section 17, which only applies to periodic tenancies. So I'm going to skip and I'm going to jump to the part of just going to okay, argument claimants, just right. So that's number 4, which I would like to focus, that there is a little, if any, prospect that this claim will succeed. Right, so that's the two parts I'm focusing on, 3 and 4. And also, in order the claimant should show cause, that's number 2, just below that it is ordered that. It is ordered, okay, I'm gonna begin with point 1 here, then Drive Manor Limited, a substitute for Nicholas Monty as defendant in this case. So we have 2. It is ordered that the claimant should show cause why the court should not, on its own motion, strike this case out as having no prospect of success. Right. So the reason I've placed them side by side, so the viewer can compare them live, pause, and make their own references as to what actually has been generated in A and B. So there is a reason as to why they've been made into documents side by side. Document B, we have 14 of October 2025, myself and Mr. Monty. So we have the name of the judge, just like the one here in document A, and in document B, 2 different judges we have. And I'm going to stop. It is not possible to simultaneously accommodate all of the claimant's request adjustments, e.g., all communication in writing and hearing remotely by video. So that's document A and B from the court. And we have document C and D from the representative of Drive Manor Limited. I will come back on that particular wording without prejudice, as safe to cost, as I mentioned at the end of the documents. I will be making the analysis, so I will leave that as it is. So I'm having here the date, it's 4th of June 2025. We have the reference number, and we can note here what actually and how actually was generated. Mr. Tarot by email only. So let's have a look. I'm going to zoom quite a lot here so it will be easy for anyone to read. So we write further to correspondence, that's paragraph 1. And paragraph 2, we know that you purport to tender those in relation to section 13, the sum of £632 per calendar month. Paragraph 3, having reviewed the documents they have provided, deceased assured tenancy would pass under his will or through his estate. Paragraph 4, probate in respect of his assets or whether there is any intention to do so. I'm just scan reading that paragraph 4. And also I'm going to just skip 5 and I will stop at 6. If you're therefore able to satisfy us on the first option, then we will take our client's instructions and so on to continue on the monthly tenancy of 632, but please be aware that a further increase is overdue. If you are not able to satisfy us, then the monthly tenancy can be granted to you on a assured basis, but at an increased rent to be agreed between the parties. This will be no less than £750 per calendar month. So we have here, I do apologize. So we have here 4th of June 2025. Then we go into documents D. which is dated the 18th of December 2025. On here this time, what I would like to just focus is that basement flat, Mr. Tarak, and we have basement flat, we have the address first class also by email, and document C back in June it was only by email. So here in this document we can see on the letter of the defendant, you will be aware from the recent hearing that the judge indicate the likelihood that your case will be struck out, I do beg pardon. The assumption is that there will be, and you have been asked to show at the next hearing good reasons why it should not be. That's in paragraph 1. You have requested a fixed term as part of your application, which we'll soon find out, which the court is simply not in a position to grant, and you are not in a possession of the original tenancy agreement. We have advised you previously that our client would be prepared to recognize you as a periodic tenant under the assured tenancy for an initial rent of 775 per month, not to be increased for a period of 6 months. You will appreciate that our client has incurred cost in respect of the proceeding, and they are entitled to request a contribution to the same. Cost are in excess of £3,500 plus VAT. Our client therefore requires you to agree to pay half of those costs that should not be incurred, that should have not been incurred. Please be aware that if your claim is struck out, our client will be entitled to all of the cost. This offer remains open for acceptance for a period of 21 days, given the Christmas period, but we invite you to respond at the earliest opportunity. And should you fail to accept this offer, we reserve the right and into the court's attention to the next occasion. So we urge you again to take legal advice on the matter. You sincerely, we have here. Right. So document E and document G. Now these documents are what actually it means. A potential future judge would be able to have a clear understanding what actually it means. Amendment slip, I do beg your pardon, claim number, Tarak, Drive Manor Limited, amendment under CPR 17, permission sought at hearing date the 15th of 10 2025. So we have here the 2 points which were made: substitute Housing Act of 95, and we have the Housing Act of 1988, section 17. So we have on 2 section 17, when a solely assured short-hold tenant die, the tenants invested in the person who was living with the tenant as their spouse, civil apartment. This includes partner living as such. And 2, we have occupied the dwelling, I believe I'm pronouncing this correctly, as their only or principal home immediately before the death. On the 18th of December 2024, upon the death of the solely assured tenant Philip George Shepherd, the tenants invested in the claimants by operation of Section 17 Act 1988, Housing Act 1988. The claimants having lived with the tenants as his partner and having occupied the dwelling as his only or principal home immediately before the death, according to the tenancy, did not devolve to the estate. So that's my signature, my name, and dated on the 14 and the 15 as well, which is not here. So we have, that was the date, and we can go to draft order document G, which that's again my document. So again, we have in the county code Brighton, Drive Manor. We have statutory succession upon the claimant's application date in 16/10/2025. Claimant supplemental witness statement with exhibits 1 4. It is ordered that the statutory succession, I'm just going to zoom a little bit more. Statutory succession. The court declared that the claimant succeeded to the tenancy of lower ground floor 10 Paston Place, which Brighton BN2 by operation of Succession 17 Housing Act of 1988 on the 18th of December 2024. Alternatively, if the court is not minded to determine on paper, the issue of statutory succession is listed for a 30 minutes determination at the next available date. Right, I'm going to skip some of the data here as my brain is becoming into an overload mode at the moment. Party substitution. So we have Drive Manor, specific by 4 p.m. service, any tenancy agreement, witness statement, rent ledger for interior rent handling, reason adjustment or communication to from the claimant shall be in writing, email with plain English action point, document shall be searchable PDFs, claimant shall have additional time for response and frequent breaks at hearing. The claimant may have a support presented. The next hearing may be remote or hybrid if required. Costs in the case. Right, so these two documents, I will be coming back right at the very end and the actual purpose. What actually does it mean to amendment slip and draft order in legal settings? So we have a document E, the full document of E, which is E1 and E2 will be at the bottom. So this is a letter to Brighton, His Majesty's Court, Brighton County Court, District Judge. And here on the right, it's my address, my name, my email, and so on. Now, one thing needs to be taken into account. 25th of November 025. It should have been 2025 and not 025. So we have the claim reference, that's an open correspondence, that's a letter to the judge. So thank you for your directions as relayed by Mr. Young, dated on the 21st of 11, 2025 regarding that should be a form EX07 form. For the record, I have already provided my account of the hearing and the memory of what occurred on the 15th. I have previously invited His Majesty's Court to rectify my account if any part of my submission was not accurate. With this in mind, there is no longer any urgency for me to provide what happened on the day of the hearing. My disability was acknowledged by Judge Hay in the order dated 14/10/2025, yet by His Honour on the 15th of 25, my adjustment requests were denied. The order of 14/10/2025 and the record of 15/10/25 do not align, particularly in relation to the inconsistency that although my bundle was found not legible, the court had previously confirmed in July 2025 that the bundle had been read only and only fees needed to be rectified. So I'm just going to, I do beg your pardon, apologies. So in document That's the continuous, the same document of E. As we can see, there is no requirement for me to speculate further about the law or the evidence already submitted. I also note that I submitted two small supplemental bundles which, to my knowledge, were not before His Honor on the day of the hearing. How the case conclude concludes is now for His Majesty's Court to determine. There is no written contract yet. Dean Wilson have confirmed the tenancy is assured and not assured short halt in their letter of 4th 6 2025. Other documents was provided in my second form, which N244, dated 1610, should have been 2025 and not 225. Whatever decision it's made, even in the event that the case is judged to have, I apologize, no merit, I will abide by the judgment, including the prospect of being ordered to pay £30,000 for the landlord's barrister, as your Honour mentioned in court. Since findings were made without full consideration, of the three sets of bundles, I can only defer to the court and await the final judgment. I enclose for His Majesty's Court on records that the documents that are, apologies, allow me to reread that paragraph. I enclose for His Majesty's Court on records the documents that are already in His Majesty's possession. That makes sense. Yours sincerely, my name, Dean Wilson, 1, 2, and 3. So that it's in document E as a document, a two-page document, I meant to say. So we have in document F, which we have my name here right on the corner. We have Dean Wilson, which is the representative, and that letter has been submitted only by email only. Statutory succession, Housing Act 1988. Just goes a little bit more. Section 17, open correspondence, 19 December. That should have been once again 2025 and not 025. Dear Miss Whiteman, I acknowledge receipt of your letter dated the 18th of December 2025. I also note your earlier letter dated 4th of June, headed without prejudice, safe as to cost. For the avoidance of doubt, the only material issue in dispute is statutory succession to the assured tenancy following the death of Mr. Shepherd on the 18th of December. Apologies. So we have a document F1. My position remains that the assured tenancy vested in me by operation of law. Pursuant to Section 17 of the Housing Act 1988, and the statutory requirement are met on the basis of the evidence already provided and filed. Accordingly, one, statutory succession is not discretionary and does not depend upon your client recognizing it. Statutory succession is not dependent upon producing of the original written tenancy agreement probate, nor upon the grant of any new tenancy, nor upon any fixed term being granted. I do not accept, number 3, I do not accept the premises I believe that should read. that your client is entitled to substitute a new arrangement as an alternative to statutory succession. I will not engage in correspondence concerning rent negotiations, fixed term, proposal, or cost threats, as these are collateral to the statutory succession. Please identify precisely A. The statutory basis on which succession is denied, and B. The specific factual elements you contend are not satisfied. Otherwise, please confirm that your client will update its record to reflect my status as successor to the assured tenancies, and it will deal with me accordingly and not misleading your client. This is an open correspondence, so we have on the final page, for compliance, I attach your correspondence exactly as received, including material marked without prejudice. Save as to cost. Nothing in this letter is intended as a waiver of any privilege that may apply to such material. My name, we have who it's been CC'd here, that's the Ministry of Justice. We have Lady Chief of Justice. We have Brighton Peer County Court, which is His Majesty's Court, and his the judge who dealt with the particular case, District Judge by Brighton County Court. Attachments of the two documents. Right. Well, this is the end of the documents which I've disclosed as the preview. Now, here is the part where I would make a brief analysis on some of the data. Now, the wording of without prejudice. This is supposed to mean, in layman's terms, is that when a party uses without a prejudice, letters, they not be admissible to His Majesty's Court, providing the offer is a genuine one and it's not being misused in a form where it's taking advantage of the opposite party. Now, when someone uses without prejudice letters and a compelling, I'm just going to go to, and a compelling a person to sign a new contract at a higher rent and generate a new agreement, the meaning of without prejudice has no longer shielding. Now, it is very surprising that any lawyer will use this wording when it's compelling the opposite party to sign a new contract with a new agreement. It's quite peculiar. So, why on earth would anyone would have been inclined to do that? It is beyond my comprehension. There again, Dean Wilson, it's a firm that has been for over a century now, I believe. So therefore, there must be some kind of reason behind it as to why they would be inclined to use the wording without prejudice, and at the same time knowing that compelling someone to sign a new contract, it is not a genuine offer. Now, I'm just going to go to the drafts here. Now, on the drafts, I can see that in document B, His Majesty's Court and the judge at the time who generated that document B had identified my needs for adjustments. And in document A, which the document was generated on the 14th of November, my needs were not acknowledged. What is the purpose of it? I don't believe that I need to know. I will leave that for further analysis to be made by His Majesty's Court and a judge, and judges who deal with those uh, understanding of the purpose and meaning of when someone uses words in a legal settings. So I'm just skipping up here and I'm just gonna go to my amendment. Those are the two documents which I wanted to talk about in a very short term as a layman person. Document E and document G. Now, these two documents are the part where His Majesty's Court engage. These are the actual documents where a litigant in person will be telling what it is that they seek. So in document E, it's clearly what I've asked for. It's section 17, 1988, which is a periodic tenancy. It is an assured tenancy. It is not a short hold tenancy, which I will disclose at a later date when I've addressed His Majesty's directly in open correspondence. And Lady Chief of Justice and the Ministry of Justice as well, which they have been CC'd into the letter as to how actually His Majesty's Court and the judge conducted the hearing when I had to go through. So the draft order again, so we have seen the amendment slip with what actually it means when someone writes to a court and if they have to make an amendment, the part, no matter how many points they're going to make onto the amendment slip, it's what the person, individual litigant in person, will be writing to what it is that they seek. Now we can see on this amendment slip, I cannot see unless someone else will be able to read it for me, if they're able to find it, as I'm not a native, so perhaps someone will be able to point it out. That on this amendment slip there is no part where I seek a fixed term. So I'm going to go to part G, the draft order, which that's upon the claimant's application dated the 16th. Now, the bundle, it's already available in a digital format, which is on my profile of my Twitter profile, and there it can be read, as it will take you to a different page where you will read the digital bundle, which has been turned into a digital book. So this is where a person can read the full bundle, what documents have been presented, and there again in the actual bundle, and the bundle can consist of hundreds of pages and so on. Now, what the guidance, it's a guideline that draft order, when the person writes, it's what they lay out to hear what it is that they seek. So in this particular document, again, draft order, I cannot see anywhere that I have been making a request for a fixed term, as what was pointed out on the draft of His Majesty's Court, that a fixed term has been made a request. Now, these are the four documents, the judge's order, which I just write here. A and B are the two documents what they matter for the person, what will be the outcome, and what it will be on the day of hearing, and so on, and what is the end outcome. So in my document draft G, again, just doing quite a lot. And then see, so specify disclosure, CPR, which is all legal terminology into what needs to be done, any tenancy agreements, and so on. So there is not a single part in this particular document, this draft order, that I have explicitly, implicitly made a claim that I seek a fixed term contract. So where His Majesty's court has extracted this, it will be interesting to know, as the guidance are these two documents, document E and document G. These are the two documents that are required for a judge to be following. I believe that for a short analysis on these documents from His Majesty's Court and defendant, it's more than adequate as a preview. So I will continue by disclosing more data, and I will try to focus and work on other cases by making a previews, and hopefully once I've completed each case by case, then that will be the full podcast per case. I do find it very strange as to when a party presents documents and data, my understanding, at least, it has been that it's the data that why it's required, the documents that when a party would need to focus. And without having to dive into a very deep analysis and make any speculative um, thinking, it is very strange to how actually mechanism are being developed to function. And yes, so I would like to conclude this short podcast, and I'm very grateful to those who would find the data beneficial for themselves, for litigants in person, as an example, or at the same time, His Majesty's Court and potential judges who will uh, be given the data for them to also compare and make their own judgment based on data evidence rather than speculation. And I wouldn't know what else might be there that it will remain unknown to me. So thank you very much, and hopefully I'll be able to begin with the other uh, podcasts. I would like to wish you a pleasant morning, afternoon, or a very pleasant evening, depending on the time of day that the viewer will be watching the short podcast. I would like to take this opportunity also to apologize in advance on regarding the uh, errors that I have been making throughout, as I do know that I do make errors, as I tend to uh, stumble on many other areas. So, thank you, apologies, and all the very best. Goodbye.